Dan Achola Okoth, Scarlett Susan Okoth,
Present, Your Honor.
Jerry Zachary Okoth,
Present, Your Honor.
Evelyn Adhiambo Zachary,
Present, Your Honor.
Jared Peter Kwaga,
Present, Your Honor.
Christine Akini trading as Atina Services and Donkey Press.
Present, Your Honor.
Joram Opala Otieno trading as Mark Tebal Contractors, Deltrack ICT Services and Teletrack Consultant.
Present, Your Honor.
Ochada Patrol Wares, Joyus Business and Swiftcon Engineering.
Present, Your Honor.
Penina Auma Atago, Caroline Anyango Ochola,
Present, Your Honor.
Misoft Limited,
Present, Your Honor.
Touchdown Visitors Limited, Engineering Limited,
Present, Your Honor.
Dolpha Softwares Limited.
Present.
But the interpretation I'm going to give
For the interpretation I'm going to give
before this court
before this court
shall be the right thing.
shall be the right thing,
So help me God.
so help me God.
For the first accused, my name is Kilokumi. I appear together with Miss Mwanzia. For the second accused, Mr. Owiro, together with Mr. Ochoa. And fifth accused, Miss Eva Kaditi. For number 6, 7, and 12, Skippy, Learned Counsel watching brief for Eacc. Certain fundamental issues were raised. The preliminary issues bear a potential of rejection of the plea agreement at the preliminary stage. This court has deemed it prudent to settle the preliminary issues in limine before taking a step forward towards considering the plea agreement on its merits. And so, I will first invite Ms. Nana, Learned Counsel watching brief for Eacc, to shed light on the issue raised by Learned Counsel, holding brief for her. Proceed, Ms. Nana.
If you'd revisit that issue, just for clarity purposes, to understand that you're reading from the same script.
Just continue. In case you don't cover it, I will raise it.
Very well. So, Your Honor, I believe the issue arising is the question as to why the Eacc has not signed the plea agreement that has been filed in court. You know, just to give a genesis of this matter, you granted parties leave on application by the counsels for the accused persons to proceed and engage in plea negotiations. We attended various meetings conducting the said negotiations. And the last meeting was held on 28th of August.
Slower.
Several issues arose. In that there was an indication that there was a plea agreement that was to be entered into, that was to be signed, sorry. Now, as representatives for the Eacc, we requested for the draft plea agreement as the practice has been that once negotiations take place, a draft agreement is shared between the two institutions, the Eacc and the ODPP, where we subsequently seek instructions on the draft agreement. We requested for the agreement, the draft agreement, but the same was not availed to us. It was actually objected to by the counsels who are there for the accused persons and also the prosecution. We were not able to even gain sight of the said plea agreement to know the contents. And the next time we got to know about the plea agreement is when we came before you, when my colleague came before you on 1st, when it was indicated that the plea agreement is already on record. Your Honor, in view of the circumstances, we have not been able to peruse the plea agreement. We have not been able to seek instructions on the same. I believe, Your Honor, I have covered the issue that you had raised. But you are still amenable to have the said plea agreement shared with us so that we can seek instructions on the same.
Come again.
I'm saying we are amenable to having, subject to your directions, having the said agreement given to the EACC so that we can seek instructions on the same. That's all, Your Honor.
Very well, thank you. The question I had has been covered. Thank you.
That what they had requested from us was that we engage in alternative dispute resolution mechanisms with the aim of settling this matter out of court. I remember,
Slower.
sorry,
Continue.
yes, that when we came back before you, we informed you that we had agreed to settle the matter via plea bargaining.
By we, you mean?
Yes, the teams, the accused persons and EACC provide their communication to the office of the DPP in a letter dated 19th of May 2025. The request from the defense, let me just clarify, Your Honor.
You mean?
Yes.
I wanted that we in context.
Yes, that is what I want to clarify. The request was for alternative dispute resolution mechanisms. We have quite a number. So the one that we settled on as a team, that is the defense team, representing the accused persons, and the EACC provide their letter to the Director of Public Prosecutions, dated 19th of May 2025, was that they were amenable to the matter being resolved through the bargaining. So we started the process by communicating to the accused persons through their counsel and to EACC, inviting them first. The meetings were held between ourselves, EACC, and counsel representing the accused persons.
That was on.
We have attached the various attendance sheets. We had a meeting on 22nd of April 2025, 27th of June 2025.
Come again. Fast.
The first meeting on 22nd of April 2025, Your Honor. 27th of June 2025, 25th of July 2025, the last meeting that was alluded to, where the agreement was discussed, was held on 28th of August 2025. During these meetings, issues to do with the case was discussed, the settlement agreements, the consent order, And the payment,
Slow. It's so funny.
sorry,
Today the machine is not running, so that
Okay.
is why I came to capture each one person through your lips. Discussed.
yes.
The details.
Yes, the details are, we have
Sorry.
attached all that in the clear
Just come again on that.
Yes. The issues to do with this matter were discussed, the genesis of the agreement between EACC and the accused persons in the civil suits. And Your Honor, even during the meetings, we made parties aware. I remember during the last meeting, minutes are available. We informed the team, or rather the teams, that what we had agreed on was what we had indicated in the plea agreement. So discussions were, we had discussions with all the teams. And on 28th of August, when we had the plea agreement, we requested the team from Eacc, we informed them rather of the contents of that plea agreement. They indicated to us that they had no instructions. You know, this is after 3 meetings.
Slow. Okay, quickly.
Sorry.
Watch the pen. That was the rule, the old rule. It was still. Senior counsel can confirm that. That's true.
This was after we had discussed with them in our meeting on 27th of July 2025 and informed them that we intended to avail the plea agreement in our next meeting. Our assumption was that because they had been attending all the meetings as scheduled, then what was being discussed in the meetings was then being reported back to the office.
By office, you mean?
I mean, they were coming there as representatives of EACC. We were sitting there as
By office, you
representatives.
mean?
Yes, yes, yeah. So it was clear, even in our letter inviting them for the meeting on 28th of August 2025, that the intention was then to sign the plea agreement. Then after they informed us that they had no instructions, as prescribed by section 137, the prosecution went ahead.
137.
Yes. The plea bargaining on who should sign the plea agreement. So we went ahead to sign the plea agreement with the accused persons. Considering that this was happening on the 28th of August 2025, that this was happening, this agreement signing took place on the 28th of August, and the matter was scheduled for hearing on 1st of September. We did not refuse to hand over any agreement.
Behind you. Not
Refused to hand over any agreement. Parties had been attending these meetings. They were aware that that was the day we were going to sign the agreement. I have deliberately left out the issues to do with the settlement in the civil suit. I will leave that to the defense team. So looking at the law of plea bargaining, Your Honor, it is our take that we complied with the law. We have attached copies of attendance sheets. We informed the Eacc of the request from the defense. As indicated, they communicated by the letter stating that they were amenable to this matter being resolved through plea bargaining. That is all for now.
In the office of the DPP, Eacc does not feature at all in Article 157. In matters to deal with withdrawal of a charge, only 3 parties feature under the Constitution: the accused person, the office of the DPP, and the trial court. Those are the only recognized parties by the Constitution.
if you can be slow.
Yes, I'm sorry, Your Honor. I will watch the pen.
And I know you don't come from the lift. I wonder where you're getting that speed.
And Your Honor, I wish to draw your attention to a provision that is very well known to you. That the office of the DPP, in the exercise of its prosecutorial power, is not subject to the directions or control of any other authority or agency. In this particular case, Your Honor, EACC is fundamentally with the constitutional power vested in the DPP. They are trying to exercise control. They are trying to direct. Sorry, Governor. Yes, they are trying to control. Yes, they are trying to direct the office of the DPP contrary to the Constitution of Kenya. And that cannot be permitted. And Your Honor, we must put things into context. EACC is acting as a complete pretender in these proceedings. EACC and the charge sheet will confirm they were the complainants for the case to be instituted, for the criminal case to be instituted. After invoking the criminal justice system, they went to the civil courts. And there they filed suit number 32 of 2018 and suit number E10 of 2021. Your Honor, the claims in the civil suit, the claims in this criminal court are exactly the same. EACC was claiming for 73,474,376 and 90 cents.
Come again, 73 million.
73,474,376 and 90 cents. That is what they claim in the civil suits, and that is what is reflected in the charge sheets. This same EACC entered into negotiations with the accused persons. I personally attended those negotiations. And the starting point of those negotiations were that the criminal case will be withdrawn and the accused persons will make a settlement in the civil courts. And indeed, Your Honor, on the 4th of June 2024, sorry, Your Honor. Indeed, Your Honor, a settlement agreement was signed on the 4th of June 2024 and filed in the 2 civil cases. In that agreement, Your Honor, the accused persons surrendered to Eacc immovable properties valued at Kenya shillings 235 million.
Come again.
In those settlement agreements, yes, the accused person surrendered properties, immovable properties, worth 235,600,000. Your Honor, you will note that is triple the amount Eacc was claiming. And why is it triple? It is triple, Your Honor, because it was assumed if the court were to convict, the accused may be ordered to pay double of the sum that was in question, in accordance with the Anti-Corruption and Economic Crimes Act. And Your Honor, to use strict language, Eacc were completely sorted. And for them to turn around and try to depict the office of the DPP as if it is doing something wrong is a public relations gimmick of trying to take a higher moral ground without any justification whatsoever. More importantly, Your Honor, we need to ask the legal question whether the Eacc is a party to the plea agreement and whether it is required in law to sign that agreement. And the answer is no. Eacc was invited to the plea negotiations out of sheer courtesy, out of civility, out of good manners. There was sorry.
Pause after every.
I will watch the pen of this.
Out of courtesy,
Yes, civility
civility,
and good manners.
good
There was no legal obligation whatsoever to have Eacc in those negotiations. Next time they should be kicked out. Withdrawn under section 87A. Your Honor, with your permission, I will just read what this section says, subject to section
That is what?
137A.
Thank you. I'm
Yes.
aware of the context.
You are aware of the context. But the point I just want to make is only two parties are identified, the prosecutor and the accused person. And then 1B says the plea agreement could constitute withdrawal of the charges. Your Honor, I also wish to draw your attention to 137B. It identifies two parties, the prosecutor, the director of public prosecutions, and the accused. The complainant does not feature at all. Your Honor, I also draw your attention to 137E, paragraph D. It again identifies only two parties as the parties to the plea agreement. And then, Your Honor, we come to the important aspect where EACC could have a possibility of featuring and does not feature in this case. And that is 137E, subparagraph E. And Your Honor, this one is important. It says the plea agreement be signed by the complainant. The complainant here is EACC. If a compensation order contemplated in section 175(2)(b has been included in the agreement. The agreement is before Your Honor. It has not included a compensation order under section 175(2)(b of the Criminal Procedure Code. And for that reason, EACC has nothing to sign. They are not required to sign any document. They are not required to sign the plea bargaining agreement. Your Honor, apart from the Criminal Procedure Code, the substandard, we have the plea bargaining rules, and I wish to draw your attention to rule number 2, which identifies the parties to a plea agreement, and EACC does not feature. Rule 6 identifies the parties to that agreement. EACC does not feature.
Your Honor, we urge that you make that determination in limine. In favor of the DPP and the accused persons, so as to proceed with the substance of the matter. That will be all and most.
Your Honor, I wish to adopt the submissions by both Mr. Kilukumi and Mr. Sajana in their entirety. Save just to add that EACC cannot probate and approbate at the same time. We are where we are because of the conduct of EACC. The groundwork or the genesis or the basis of the plea agreement placed before you arises out of a consent or an agreement that EACC had executed in the civil cases it has been mentioned. That agreement, Your Honor, under the Act, EACC Act, Cap 65, that settlement forms part of the report of assets recovered, and that report annually is submitted to the people through Parliament for approval. In those two suits, civil suits, sorry. In the two civil suits, sorry. The office of the ODPP were not parties. So in reaching that settlement, it was at the sole discretion of EACC who were deemed to have acted in the best interest of Kenyans in general. So there was public interest covered in the civil suits. And as submitted, that report will be laid before Parliament for approval. And those are the representatives of the general public. So if we are to subject that settlement to the omnibus test, we are represented by the parliamentarians where the report will be presented. Now, when it comes to this criminal suit, what does the EACC, the Anti-Corruption and Economic Crime, Cap 65, state in section 37, which deals with the annual report on prosecution? This is what it stipulates. 37 clause 1 stipulates the director. 37 subsection 1. 37.
You can give us some, please.
Yes, just to summarize. The director of public prosecutions shall prepare an annual report with respect to prosecutions for corruption on economic crimes. Your Honor, this is just to lay the emphasis that the powers to prosecute in economic crimes, as in this case, that consent to prosecute or to withdraw rests with the office of the ODPP. And in executing the plea bargaining agreement, they have done it within the powers in this state under section 37(1) and the Constitution. Lastly, for purposes of your record, Your Honor, as officers of the court, we must be candid and honest. Eacc, through its officers, has been participating in all meetings leading to the preparation of the plea agreement that has been filed. I think there's an element of dishonesty on their part to try and disclaim that they are not aware of the report. Your Honor, we were before you. Sorry. Sorry, all right. We were before you on Monday, which I believe was the first, when the report was filed. It was present, and the officers from Eacc were present. When the matter was adjourned, you are aware of the filing of the report. So even if you were to give them the benefit of doubt, they would have accessed the report because it's available in the court file. You are aware of its filing. They participated in the proceedings on Monday. So, Your Honor, they cannot be heard to be saying today that they are not aware of the existence of that report. That is dishonest. And I submit that their application should be disregarded and we should proceed as submitted by me. I agreed that the proceedings on the plea agreement should proceed. Thank you, that's all.
The error of submission by Senior Counsel Kyogo and my two seniors, Mr. Sagana and Mr. Ocho. Your Honor, slow. Continue. Your Honor, I come to the humble conclusion that there is nothing more to add to this submission. Your Honor, we will be seeking to adopt the minutes as submitted. That is all.
We wish, Your Honor, to adopt and appreciate ourselves fully. And we are very able submissions by my senior, and my three colleagues who have spoken ahead of me. And Your Honor, as you proceed to look into this matter in a minute, it is our take also, Father, that indeed there is no application before you per se. In opposition he intended to achieve and adopt this morning. And I believe there is no impediment that is before this court at this juncture that will deny the parties an opportunity to reach their goals and intention to enter a plea bargain as early intended, and scheduled by the parties before this court this morning. I don't want to submit any further because I may run the risk of addressing issues that perhaps the moment of opportunity has not come. Once the document is properly placed before the court, we shall address you further if needed.
So, Musa.
Last but not least.
Yes, last but not least.
Wish to submit on the same,
That is in order.
and I would wish to have the same addressed by my senior Mr. Bishal Injil.
By responding to the DPP's
If you can project kindly.
allow me to start by responding to what the DPP has indicated to this court. Now, Your Honor, the practice of plea agreements is that once the parties have come up with a draft, the draft is shared with all the relevant parties. If there are amendments, if this any editing, the same is done. Parties that need to seek directions or instructions from their principals do so. And once all issues are agreed upon, then the pre-agreement is signed. Your Honor, that is the practice that has been established. And this practice is in line with Section 137A-O. I will be coming to that shortly.
Section
137A-O of the Criminal Procedure Code as far as the plea agreements are concerned. Your Honor, if EACC's participation is not required in this process, then the slot for them to sign could not have been included in the pre-agreement. I'm sure the...
slower.
Sorry, Your Honor. I'm sure the pre-agreement filed in court, as indicated by my colleague, we have not seen it but I'm sure it has a slot for EACC to sign. And that is what drew the attention of this court, because the court knows the practice. Your Honor, our issue is very simple. We be served with a pre-agreement. Or the pre-agreement is available to us. We seek instructions. If we are told to sign, we sign. And we have no issue with that. We just need the pre-agreement. We seek it. Okay. Okay. Sorry, Your Honor.
Kindly watch the pen.
Okay. I mean,
yes. So I stopped it. If we are asked to sign, we sign.
Your Honor, what I'm saying is,
No, I'm just giving you direction where I am.
yes,
That you pick it from there.
yeah. Once we receive instructions to sign, we will sign, and the instructions must come from our bosses. So we just need the pre-agreement. Now, Your Honor, in regard to the participation of EACC in pre-agreements, I will invite this court to look at the relevant section, that is 137A to 137O of the Criminal Procedure Code. But allow me to draw the attention of this court to section 137D. Now, Your Honor, kindly allow me to draw the attention of this court to section 137D. D for dog. Allow me to just state that it provides that the prosecutor shall only enter into pre-agreement in accordance with section 137A, and it provides, A indicates after consultation with the police officer, investigating the case. Now, the police officer investigating this case is EACC. Because the matter involves corruption and economic crime. Now, when we look at 137B, 137D Part B, it goes ahead to deal with some aspects. That must be put into consideration before a pre-agreement is arrived at or is arrived on. For example, nature and circumstances relating to the offense. Another example is personal circumstances of the accused. And finally, interests of the community. Eacc being the mandated, the constitutional institution that is mandated with the fight of corruption in this nation. Is in the best position to provide these three issues, or these three considerations, these three aspects in the process of plea agreement. It is only the investigating officer who can be able to provide these aspects. In regard to C, I wish to state that to 137DC, I wish to state that Eacc is here, ready and willing to play its part as far as this plea argument is concerned. Your Honor, that scores the importance of participation of.
Come again.
Your Honor, that scores the importance of the participation of Eacc. Without this participation, the pre-agreement does not meet the requirements of section 137 A to O. Your Honor, it is true that my senior Kirkubi has agreed that Eacc is the complainant. If you, as you retired, write your ruling on this issue, kindly look at section 137E. 137E of the civil criminal procedure code. Now, in regard to the civil matter, Your Honor, where a consent was entered, I wish to draw the attention of this court to section 193A of the Criminal Procedure Code. The civil matter has no bearing in this matter, in the criminal matter before you. If the defense wants to use the concept that was entered into, let them use it as evidence or even use it for mitigation if they will be convicted by this court.
Yes, Mr. Walker.
I didn't want to do this to my senior, but the EACC is delving into new issues which were not
Into
new issues, and are delving into the substructure of the agreement. Now we will not have an opportunity to submit on those new issues. We do urge the EACC to stick to the rules of order and not attempt to steal a marginalize. It's still more.
objection raised by learned counsel, Mr. Owino. The response to that objection by learned counsel, Mr. Ishangi. The court issues the following broad direction that in your submissions be guided, number one, by the specific issues which were raised by learned counsel watching brief for EACC. And number two, be further guided by the new issues raised by learned counsel representing the accused persons. Beyond that, including raising issues of mitigation and evidence in trial, those are completely outside the circle of the issues before us. Continue, Mr. Ishangi. Mr. Ishangi?
Yes.
High Court?
Yes, it was in the High Court. Yeah. ACC case number 32 of 2018.
So ACC
32 of 2018.
at which court?
The High Court. The Anti-Corruption Division.
Anti-Corruption Division.
Yes. Then we have 10 of 2021.
No, you can continue. That is all I needed to add.
Fine. Your Honor, you'll see that no such condition was introduced. That is the condition to withdraw the criminal matter. Your Honor, if the DPP wants to withdraw this matter under Section 87A, as a practice, or as the practice is, let them make a formal application in court it will be responded to. If the DPP wants to withdraw this matter under section 137, and then as indicated, the pre-agreement has to go through the process, or it must be in line with the provisions of the law. In regard to the rules, 2614 of the pre-agreement, those rules are subject to criminal procedure code. Your Honor, finally, let me indicate to this court that any corruption matter or any pre-agreement that is dealing with the corruption matter, and corruption issues are issues of public interest, as it were, in this nation. It will not be correct for anyone to say or to indicate to this court that the body that has been mandated by the Constitution to fight corruption has no role in such a pre-agreement. Thank you, Your Honor.
Jeffrey Onyago. I'm shy. Yeah, Jeffrey Onyago. I read about this matter in a local print a couple of days ago, and I've been following up about this case. And a few days ago, I approached the registrar. They told me the matter already been settled. The what? The matter has already been settled. And later to come to find out it has not. So he advised me I need to write to you or to both courts, because the subject is basically two cases. My apologies for the subject, but it depends on how counsel applies.
Yeah.
So the subject, Mr. Obado, has two cases pending. Yeah.
Your Honor, kindly allow me to talk also.
No, this time you will.
I don't want people who are imposed distance.
There's nothing wrong about that.
They know.
Okay, I'm sorry.
They are crucifying me for nothing. This fake guy has come here. Your Honor, this one, I also have my right.
Yes.
This fake guy can't come here to start tarnishing my name. Knowing very well that they crucified me for something that I should not have been tried for.
Very well, Mr.
He's a guy I've never seen in Migori. Where do you come from?
Mr. Obado, have your seat. Have your seat. Have your seat. In one sentence.
Mine is easy. I want to file an application, an objection based on all interface. Everybody has spoken.
Oh, you want to file an objection?
Yeah, based on the
current. Thank you.
That's all I want to do.
Thank you.
Based on quantum and time.
Thank you.
Physics. I'm sorry.
Before going, I've not given directions.
Okay, I'm sorry. I've heard about you, and I've seen you tell me.
So you want to file an objection?
Yeah.
In your capacity?
As a citizen of the Republic, as humanity, because the
Answer my question
okay,
in
so,
one.
Okay.
Your capacity as what?
As a citizen of
full stop.
Okay.
No further.
Okay, thank you. And thank you for allowing me this.
No. Before you leave.
Okay.
So everybody is at liberty to do whatever they wish, so long as it is within their rights and power.
Okay.
And and you will get further advice from the registry on how to proceed in that respect.
Yes.
Once,
Okay.
in the event it lands before me,
Okay.
I will proceed as the law directs.
Thank you. God bless.
Thank you.
It's gonna be okay. Keep up the good work, everybody.
This court will take a break for 20 minutes to craft some guidelines and directions on the way forward. We therefore will resume sittings at 12:20. 12:20 for the directions. Thank you, and I think unless you need a longer period, no, 20 minutes. Issue beyond this specific issue. It follows that except the said specific issue raised by Eacc, the other rival questions of law have not ripened as to require immediate disposal by this court. Concerning the principal issue raised by Eacc, it will be imperative to underline that although not obligatory upon the DPP, sharing the draft plea agreement with Eacc is a practice which has received acclamation and approval by this court in the past as the gold standard practice, fundamentally because of the spirit of negotiations and the fact that Eacc participates in the said negotiations. It thus remains the best practice, and I find no ground to fault it. Eacc having indisputably participated in the negotiations leading to the plea agreement now filed in this court, it will therefore be prudent that the DPP shares the plea agreement with Eacc. Accordingly, this court stays determination, underline that one, stays determination of the other rival questions of law raised by all parties, and directs that within a period of 3 days, the DPP formally shares the specific plea agreement filed in court with Eacc to deal with it in the manner Eacc deems fit. But in any event, within a period of 21 days, be guided accordingly. I'll share what assistant, defense, Eacc, which other criteria. We'll therefore take directions. Take a mention date, further directions, depending on the outcome. 21, after 21 days, for the system. And because it will be a mention for directions, I don't think a physical attendance is necessary. So it is a mention for directions, depending on the when then we can then fix another date, depending on the circumstances. Is that clear?
Yeah, it's clear.
Yes.
We are requesting you, if this is going to be a virtual mention,
yes,
why don't we do it early in the morning before you start your
very well. So mention on 30th September 2025 at 8:15 a.m. virtually. So in this sitting, the accused persons may wish to join or not. So they are at liberty.
Your Honor, if I may,
Yes, Mr. Ocho.
You had given us that date for 24. So what